If we're on? Good. So it's good to be with you all again. Today is the 31st of January 2024, and we are continuing our lectures on Nigerian company law. Our focus today will be on arrangements and compromise, and I will try and give us some background, arrangements and compromise. But before I give us background, perhaps we should look at learning outcomes. What should you know at the end of this lecture? You should know what arrangements and compromises entail. Dara, I hope you are with us. Yes. The role of the court. You should know the role of the court in all of these arrangements. You should understand creditor protection rules. Creditor protection rules under arrangements and compromise. The framework for dealing with dissenters. Dissenters, if people dissent, what do we do? Do we ignore them and continue? We should also understand employee protection arrangements. Employee protection, the regime for employee protection in arrangements and compromise. We should have a grasp of these, and specifically we should understand schemes of arrangements on sale, and then compromise with creditors. And we should comfortably be able to compare compromise with creditors and the CVA, the company's voluntary arrangement. Yes, so good. So we'll start with the introduction. So it's possible for two or more companies to decide to merge or to combine their operations, for obvious reasons of achieving what they call synergy and economies of scale. To achieve synergy and what economists will call the economies of scale. Economies of scale simply means that 1 plus 1 ideally should be 2, but if we combine our strengths, 1 plus 1 will not give us 2, it will give us 3. Do you understand? 1 shall chase 1,000, and then 2 shall chase 10,000. So if on my own I'm able to generate 10, and Deborah on her own is able to generate 10, if we merge our capabilities together, we will not generate 20, we will generate 30. Do you understand? Yes. So as a result of that, 2 or more companies may decide to merge. It's also possible that one company may be struggling financially, technically, in so many ways, and they may decide to harness the capabilities of the other company, and so we could have a merger. Company A may already have a license, particularly if it's a company that is operating in what we call the extractive sector. Or not just extractive sector, there are a number of sectors you operate in that you definitely cannot engage or operate in without a license. Example is telecoms. A company cannot operate in the telecoms sector unless it has been granted a license. Is that so? Yes. It doesn't work. Okay, and so if we have a company that already has a license, NCC license, broadband license, and like MTN and all that, even if it is struggling financially, another company that doesn't have that license may desire to break into that sector. Are you with me? And so may want to enter into a merger with this other company that already has a license. So many reasons may inform the decision of two companies to come together. A company may also choose to sell its assets and leave. A classic example now for us in Nigeria is the fact that several multinational companies have left the country. Many of them will not just close shop and leave. Rather, what they will do is that they will sell their assets. They will sell their assets to another company, or they will transfer their undertaking to another company. Are you with me so far?
Yes.
So these arrangements happen from time to time. Now, if it was a personal business, it would have been very straightforward and easy, because if it's a personal business, I have the asset. All I need to do is to sell the asset for you. But when it comes to companies, it's not that straightforward. It can be a little bit complex, because the company itself ideally is a conglomeration of interests. Is that so? Yes, it's a conglomeration of interests. And one person doesn't just own the company. And if that is so, we'll need to have the consent of those interests that converge around the company. And so that makes most of these procedures a little bit complex, as we will see in the course of this discussion. So 2 or more companies may agree to merge or combine their operations, and this may assume the form of a formal merger. Formal merger. It may also assume the form of an acquisition, or a business combination. It may assume the form of a formal merger. ABC Nigeria Limited has now merged with UBA Nigeria Limited. As a result of the merger, we may have a third company. We will not have ABC Nigeria or UBA. We can now have XYZ Nigeria Limited. That can be a scenario. In another scenario, if ABC already has a reputation, a brand name that is open to that is acceptable to the public, as a result of this merger, we may decide to retain ABC. Is that so? Is that so? And so UBA Nigeria Limited may go into oblivion as a result of that merger. It's still a merger, but one company has decided to continue with the name. In some other instances, Company A can acquire Company B, but they will end up using Company B's name. A good example is Standard Trust Bank and UBA. Standard Trust Bank acquired UBA, but it was not UBA that acquired Standard Trust. But UBA was more popular, and so they continued with the name. UBA itself is an African, it's a Pan-African bank, United Bank for Africa. It's a name that is more catchy compared to Standard Trust Bank. And so as a result of that acquisition, we now have UBA. So Standard Trust doesn't exist again. What we have is UBA. Somebody who doesn't know the details will say UBA acquires Standard Trust. Are you with me? But it's actually the other way around. So there is a lot of flexibility around these combinations. And again, of course, you know that 2 different companies can go into what we call a joint venture. A joint venture where Company A and Company B, they maintain their independence, yet they collaborate to do a particular thing. It's very, very common in the oil and gas industry because of the extensive risk in the industry. It is never advisable for one company to go it alone. If I have an oil block from the federal government of Nigeria awards an oil block to me, it is not in my best interest to develop that block alone, because there is a serious risk that it may flop. And so what oil companies prefer to do is to spread their risk, and by so doing they minimize risk, they minimize the possibility of failure. Are you with me so far? And so I would prefer to have a joint venture with Oyadowa and then Grace Sample on this concession. So if we have to expend $10 billion, I may have 40%. I will be 40. I may have 40%, and both of them may have 30%. So if it flops, all I'm losing is 40%. Then I will also want to have another joint venture and another joint venture. It's safer that way than to put all your eggs in one concession. So we have these combinations and relationships that acquire. Just to point out that where these combinations occur, or collaborations, or mergers, acquisitions, as the case may be, it usually has implications. It will have implications, first of all, for creditors. creditors of the company. It will have implication for third parties. It will have implication for the shareholders. It will have implication for creditors, third parties, shareholders, employees. Well, the one I've moved beyond that book. Close the book. We keep progressing. The book was last year. I keep developing my notes. Because we are learning every day. Is that not so? Yes. Anybody who, I used to have a lecturer when I was in university. The handout he gave to us was the handout his own lecturer gave to him when he was studying in the university 18 years ago. And so a friend of mine, his sister and that particular lecturer were classmates. So please come in. And so when the sister heard that he was taking that course, they had already with me. The sister now said, "Oh, my younger brother, you are going to do that course. This is the handout they gave me when I was in school 18 years ago." So she gave to him. When he compared the handout with the handout that the lecturer gave to us, with verbatim, word for word, he refused to improve himself. Every year I keep improving. Okay, so let's continue, please. In fact, I'm already working on second edition of my book. We have to keep improving. Look at it, can't just be stuck. Look at the book I'm using to teach commercial law. It's not changed. They are still using 1968 Companies Act. When we have moved into CAMA, 1990, we have moved into CAMA 2020. They have refused to change. Okay, and if you have met the man, say, "Okay, let me work on the second edition for you." You say, "No, leave it like that." Okay, so mergers, acquisitions, business combines can have implications, I say it again, for creditors, for third parties, for employees, and it will also have implications for competition law, because there's always a tendency that when two or more companies come together to merge, what we'll see at the end will be a monster, a chimera, an untamable entity, an all-consuming entity. And when that is the case, we are likely to have a monopoly. Are you with me? Are you with me, my friends?
Yes, sir.
Good. When we have a monopoly, we will have a problem. Monopolies can be good in some instances, but for the most part, they are not good. Because if you have a company as a monopoly, it will crowd out all competitors, and then it will abuse what they call the dominant market position. Are you with me? And so whenever these companies want to carry out any of these combinations or mergers, these are the concerns that we want to have. Of course, the government will be concerned significantly about a lot of things. I don't want to go too far. Now, we look at Shell, for example. Shell is divesting from all its land assets in Nigeria. But Shell is having litigation, ongoing environmental litigation. Some of them, judgments have already been issued against Shell. Some of them amounting to almost as much as 100 billion naira. The question now is that if you decide to divest and transfer your assets to this company, and you are leaving Nigeria, who is going to pay that money? There is also ongoing litigation. Who is going to clean up Ogoni land? So a lot of things are considered. And of course, the community where most of these companies operate will also be very, very concerned. Recently, Chevron wanted to move off from their operations in Onne. Chevron has some operations in Onne, logistics operations and all that. And there's a very close community there called Ogubolo. Ogubolo is not in Elemi. Onne is in Elemi. Ogubolo is in Okrika. But the people of Ogubolo are sustained by that company. So they went and protested. If you divest, what will happen to us? As far as they are concerned, the company in their life. Come in. Are you with me so far? Are you with me so far?
Yes, sir.
So these are just some things I want to give you as we try to lay foundation. Please put it on the platform. Anybody who comes in should enter and not stay outside. Okay, so because of these likely implications, because of these likely implications for employees, shareholders, creditors, competition, if you are going to merge, we are going to need regulatory and judicial approval. The government, in essence, must be involved. The government, in essence, must be involved because the company is involved. If it's two single businessmen that want to make what's our business. You have a school, and you have been operating one small school somewhere in Swali, and now you are relocating to Abuja. You want to sell the school. What is our business? You sell it. But once a company is involved, these implications will arise. And so we are going to need regulatory and judicial approval. Okay, so for Nigeria, there have been several high-profile measures, particularly in the banking sector. So in my slide, I pointed out the measure of Access Bank and Diamond Bank that one just occurred in 2019. From time to time we have these measures which you should be conversant with. And I also sent you something this morning, a scheme of arrangement. You saw it now?
Yes, sir.
Yes, Oando and then all that. Okay, so now, again, let's look at types of restructuring, because most of these measures and acquisitions are actually called restructurings, corporate restructuring. There are a lot of terminologies that you will come across that dance around this topic. In some instances, there are some differences which you ought to know. First, there's what they call it takeover. Then, Auntie, who's the book? Good, focus on the master. So there's what they call take what over. Then there's what they call acquisitions, mergers. So takeover, acquisition, mergers, and these are terminologies you usually come across. Takeover, acquisitions, and then merger. So basically, a merger is a marriage of two. An acquisition and a takeover, they are essentially the same thing. But for us as students of law, we have a separate legal regime for takeovers. You'll find that in the Investment and Securities Act. Originally, the Investment and Securities Act provided for takeovers and mergers. We'll talk about it presently, let me not jump. So these are the three terms you usually hear about. But beyond that, you also hear about internal restructuring. Internal restructuring. For example, there's what they call buyouts. Internally, we will restructure the ownership of a company. Comfort, are you with me? Internally. For example, the board of directors, the managers may come together and buy out the company from the shareholders. So we call them management buyouts. We could also have shareholder buyouts, where shareholders are buying out other shareholders in order to consolidate their hold on the company. Then we could also have what we call employee buyouts. Employee buyouts. Employees. So the employees of company also could buy out the shareholders if the shareholders want to sell. A good example is, again, I told you Shell is divesting, and some of the people coming together now to buy out Shell. The truth is that those are former employees of the company, former directors, people that are involved, and were all top men in Shell, Bereshiku Oji, Babs from Ottawa, and almost all of them were top managers in Shell. Of course, they had left, but let's assume while they were still staff of the company, they chose to buy out. So everything is possible as long as both parties agree. Okay. Please, can I continue? But our focus today will be on arrangements and compromises. Arrangements and compromises. And this may refer to, I'll read what I have here, any form of compromise between a company and its creditors or members under which they agree to accept something different from what was what they were originally entitled to. It may refer to any form of compromise between a company and its creditors or members, under which they agree to accept something different from what they were originally entitled to. So in the course of trading, a company may have problems, financial challenges. Sometimes it may not even be financial challenges, but for the most part it's financial challenges. Other times it may just be that they just want to do some reorganization. And so they may decide to have some form of arrangement and compromise with their creditors or with their members. This could be done internally or externally. Are you with me? Are you with me?
Yes,
Please, so a company could be owing creditors similar to what we looked at on Monday and is unable to pay them because of current challenges, just like the CVA. And they may call the directors may call the creditors and bring an option to them. We're having problems now, but we have great potential. Can we do a debt to equity swap? All your debts, we cancel it. In consideration, we give you shares. The shareholders, when the creditors agree, then we have a restructuring. We could also call our shareholders and say, we want to make you creditors. We don't want you to be shareholders again. Particularly minority shareholders. We could table that before them. And if they agree, then we have a compromise. So it's not about compromise, this was your stand. And now the directors are proposing something different from what it was. If you think it is better for you, then you take it. Are you with me? Yes. So, like the one I sent you, the one on Oando, what happened is that Oando had been publicly traded for some time. And they were not doing very well. I told you I bought shares in Oando 17 naira. I eventually sold them for 4 naira. So they've not been doing well, but it's like they're trying to bounce back. I try not to read it because if I read it, I'll be feeling regret. Why did I sell my shares? Because the value eventually came to 13 naira. And so the primary investor in that company decided to take the company off the stock exchange. It's been a publicly traded company. Decided to make it to delist it essentially. And so they brought this compromise or this scheme to offer the current minority shareholders, and the value of the shares of the company was 13 naira on the stock exchange, but they offered to buy it from them for 17 naira, so they were buying it from them at a premium. Is that so? Yes, so you accept. Whether you accept or not, you cannot do anything because, as you will see from the course of our discussion, once the majority of the shareholders get to a particular threshold, then they can do whatever they want. They can compulsorily acquire your investment. Are you with me? The only way you can challenge it is if you can say it amounts to oppression under section 353, 355, unfairly prejudicial. Apart from that, they can virtually do anything. And so they decided to to compulsorily acquire the shares of those investors. So that is an example that I wanted you to know. Please, can we continue? So then there could be what they call external restructuring. Just a second. Good. So can we continue? Good. Okay, so most of what I've been trying to say could refer to internal restructuring, which, like I said, could include buyouts, could include arrangements and compromises. Please listen up. Could include debt to equity swap and all that. Are you with me so far? Are you with me so far?
Yes, sir.
But beyond that, we could also have external restructuring, where, like I said, two companies are coming together to merge. One company is being acquired. So here, two companies are involved. And the first internal restructuring, for the most part, two companies are not involved. Rather, what we are having are shareholders dealing with shareholders. The company is telling you, please, we want to buy you. This shareholder wants to buy up your shares and all that. So we will have external and then internal. But for external restructuring, like I said, we usually have mergers, acquisitions, and then takeover. Now, a merger or an acquisition can arise, please listen, can arise as a result of an arrangement and a compromise. A merger and acquisition can arise as a result of an arrangement and a compromise. And internal restructuring can also arise as a result of an arrangement and a compromise. So you can use acquisitions and compromises to deal with matters internally. You will also use them to deal with matters externally. Is that okay? Good. Okay, so let's just say a few things about the framework, the legal framework, before we jump fully into CAMA and see what we can do in the next 1 hour. The framework. So I want to point out that originally Part 12 of the ISC, Investment and Securities Act 2007, had provided for mergers, business combines, takeovers, and acquisitions originally. But things changed because the provisions relating to mergers, which were sections 118 to 128, have now been repealed by section 165 of the Federal Competition and Consumer Protection Act. Are you with me? In 2019, we enacted for the first time a competition regime. Nigeria never had anything like that before. We had few provisions in what you call sector-specific legislation. So the Nigerian Communication and NCC, Nigerian Communication Commission Act, has some provisions about competition as it concerns its communications industry. But on a general note, we never had any law that proscribed anti-competition activities. But in that year, 2019, we now enacted the Federal Competition and Consumer Protection Act. And among other things, that act created an agency called the Federal Competition and Consumer Protection Commission. That commission now regulates anything that has to do with anti-competition activity, the formation of what they call cartel. You know what is a cartel, Odinaka? A cartel. Good 3, 4, 5 people come together and say, we're the ones selling this drug, amlodipine in Bayelsa. We all agree that nobody should sell it below 20,000 naira. Do we agree? Yes, we agree. What we have done is to stifle competition. Are you with me? We have stifled competition. We have fixed the price by the formation. It's an offense now. What they call bid rigging. Or you're the one who wants to come and bid for a job from Bayelsa State government. She now enters, not you anyway. The person now enters into some criminal agreements with some other people to rig a bid, to take advantage of the opponents and all that. So no other person knows how much you are going to bid. But I have an insider in government who has now told me that everybody is bidding for this job for 1 million. And we want to give it to the lowest bidder. The person who can do the job and charge us least. Now, so. And so please, since I already have this information, you bid for 800,000. And so you bid for 800,000. They give you the job. After you have worked for 2 months, you will now ask for variation of the contract. And so all that is anti-competition activity, forming a monopoly, abusing your dominance. So we now have the FCCPC, that's what I'm trying to say. And so what the Act did was to move what we used to have as sections 118 to 128 of the ISA, to move it to Part 12. Part 12, comprising of sections 92 to 103 of the FCCPA. That is the first thing you need to understand. But sections 129 to 151 of the ISA that deals with takeover was left unaffected. So if we're talking about takeovers, mergers, and acquisitions, as far as Nigeria is concerned, we are looking at three legislative pillars. One, there is the ISA, which still deals with takeover. Two, there is the FCCP Act, which now deals with mergers. Then thirdly, we now have Chapter 27 of CAMA. Chapter 27 of CAMA, which in dealing with arrangements and compromises, recognizes that mergers can arise out of that transaction. Chapter 27, precisely sections 711 to 713, which also provides for mergers through companies' arrangements on sale, and all that. So those are the three major frameworks that we have. Are you with me so far? Yes. And I pointed out in my book that the FCCP Act and the CAMA are concerned with two different things entirely. CAMA is concerned about how will this merger affect shareholders, how will it affect creditors. That is all CAMA is concerned about. The FCCP Act, on the other hand, is concerned with, will this merger result in a monopoly? Will it affect competition? Dangote refinery has finally come on stream. And one of the concerns people have had for years is that Dangote is a natural monopolist. And so the concern anybody will have is, would this refinery turn out to become a monopoly? We have Bua refinery that is also being constructed, estimated to produce 250,000 barrels daily. Assuming Bua now merges with Dangote, and NNPC Port Harcourt refinery that is producing about 200,000 now merges, we have a monopoly. And so if the regulator is going to give his consent, because like I told you, because of the implications that these combinations can have, it will require approval. Did I say that? So that is what the FCCPC, the commission, wants to know. Will it affect? Will it result in monopoly? If it will not, please carry on and all that. Again, there are instances where even if it will result in monopoly, we may still give consent if we are of the view that it is in the best interest of the country for that to happen. Thank you, Lord.
Thank you.
Okay, so for mergers in all instances, the members must first of all approve. The shareholders of the company must first approve before they will eventually approach the regulator and all that. So our focus is company law, and for company law, our focus is chapter 27, like I told you, and that is what we want to see today. Within the next 1 hour, we must be done because I have a meeting in our beloved, our Soma. Okay, so like I said, chapter 27 deals with arrangements and compromises generally. Eight sections. Section 710 deals with definition of arrangements. 11 deals with arrangements or compromise between two or more companies. 712 deals with provisions relating to dissenters. And 712 deals with provisions applicable to schemes or contracts that involve transfer of shares in the company. 713 deals with provisions relating to dissenters. 714 deals with arrangement on sale. 715 deals with what we call compromise with creditors. And then 16 and 17 deals with moratorium and all that. Please, are there questions? Are there questions? Yes, or the other one?
Sir, concerning an arrangement on sale.
Yes. We have not come there. What I'm doing today is to teach. Are you with me? I didn't come for tutorials. I want to teach because I'm doing this thing for video. So you can ask me a question based on what I have done. Yes, my dear.
Okay, sir. You mentioned that companies coming together to form a cartel. They
Yes.
decide that they should not sell below a particular price. That
Yes.
is an offense. What about the recent increase in the price of pure water that they announced?
Okay.
Officially that is now going to be at this price. Does that not amount to an offense?
Good question from an intelligent girl. I'm not aware of that announcement. Was it on the news?
Yes, sir. On radio.
On radio?
Yes, sir.
It's again possible for the government, after discussing with people in a particular sector, to agree on some form of price fixing. Because if the entrepreneurs in that business feel that free competition is harming them, because the aim of free competition is to ultimately benefit the consumers. Is that not so? But there are times when free competition itself can ground a sector. Because if the people who invest in the business, by virtue of competition, are not able to break even, will have problems tomorrow. And so where that is the case, the government, working hand in hand with those people, can fix price. A good example now is in the legal profession. Before this time, we have lawyers who can charge anything. But if we allow lawyers to charge anything, it will eventually ruin our profession. It will bring down the standard. Is that also? Is that also? Yes. So ideally, for a lawyer to be able to break even, meet his bills, and let's assume he needs 500,000 on average. If that is going to be so, then we need to have his schedule of charges. You can charge more, you can't come below. But when we have more abundant supply of lawyers than the availability of work, then we have a problem. Because the demand is less than the supply. And our universities are churning out lawyers, law graduates in their thousands every year. And so if the demand far exceeds the supply, then we have a problem. And every lawyer wants to eat. At least you don't want to go hungry now. Is that also? Yes. So if a job that ideally you would have charged 100,000, let's say they say take 15,000. I know one lawyer waiting for road to go now. But this 15,000 they give yourself, and just because I like you. You will take. I used to have a cousin. I wanted to buy land in Port Harcourt. What's in a multinational oil company? I charged him my decent professional fee. He said he knows one lawyer on the street that will do it for 20,000. And what he said is true. I said, you can go to him now. He said, what you go do for this thing? I will pay this kind of money. And I said, what are you doing in that oil company that they are stealing you millions every month? Is it not copy and paste engineering you are doing? They've done all the design in Britain. They've done the design in America. What you are doing as an engineer is to copy and paste. And you are being paid millions. Why not pay me my decent fee? And carried on. I don't know how it solved this matter. The only time when lawyers are able to hook their clients on the neck is when they come to litigation. So now the person is in problem. And you need a lawyer that knows his work. So if you go and take one lawyer on the street, and eventually they send you to prison, and you're thorough, is that also good? So I hope I've cleared that. So there are some instances where that is possible. Yes. So let's want to say something. We'll come to it. Now let's rush quickly. Good. And so our focus, first of all, will be on what we call arrangements or compromises between two or more companies. Arrangements or compromises between two or more companies. Somebody should read section 711 for us, subsection 1. But before you do that, what is an arrangement? Just look at section. Let me read section 710 first. What is an arrangement? Section 710. In this chapter, the word arrangement means any change in the rights or liabilities of members, one, debenture holders or creditors of a company. Debenture holders and creditors are the same thing anyway, but and creditors is wider. Or any class of them on the regulation of a company other than a change effected under any other provision of this act or by the unanimous agreement of all parties involved. The thing you are looking out for is a change in rights or liabilities of these critical stakeholders. Are you with me so far? Are you with me so far? Yes. An arrangement can happen. So we are arranging. Another synonym for arrangement could be compromise. In this case, so I felt you should know that. And so if you look at section 711, section 711 now recognizes that two companies in my book, I use company A for transferor and company B for transferee to make it easy. So company A and company B may agree to merge as a result of a scheme of arrangement. A scheme is basically an arrangement. As a result of that scheme, they may decide to come together. And the scheme may result in the transfer of either of the following. Number one, property, assets, or undertaking, or liabilities. So company A is transferring its property, its assets, its undertakings, its liabilities to company B in exchange for shares or funds. In some instances, company B will pay company A directly. But more usually, company B will issue shares to the members of company A. Those shareholders will now become shareholders in company B, after which company A is likely to cease to exist. So you have moved the shareholders. I'm no longer a shareholder in Standard Trust Bank. I'm now a shareholder in UBA. The assets have moved from this company to that company. So it could be a transfer, like I said, of property, of assets, of undertaking, or of liabilities. For some companies, for example, we have companies that their lifeblood is one particular asset. And so to sell that asset is invariably to say you have sold the company. Are you with me? And the moment that asset is gone, what you have now is a shell. So MTN now, the crucial thing that MTN has in this country are its licenses, operational licenses. And its telecoms business. Mass and all that. If you sell all that, even if MTN is a shelf, and that's why you see, and that the court in sanctioning the scheme will invariably order that the company should be dissolved. Shell is not being sold. People say Shell is being sold. Shell is not being sold. What Shell is actually selling are its assets. The oil block. 18 oil blocks. But those oil blocks are the lifeblood of SPDC. So in these companies, 4 companies actually are coming together. In these companies coming together have acquired these oil blocks. SPDC is now going to be a shell. And so what are we going to do to dissolve SPDC? And now begin to discuss the intricacies concerning pensions, employees, and all that. Are you with me so far? Are you sure you are with me? Yes. Good. So a scheme of arrangement is usually geared at taking control of a company. It is a corporate action in which the target directors ask the target shareholders to vote in favor of the change of control. It's usually geared at taking control of a company, and it is a corporate action in which target directors ask target shareholders to vote in favor of the change of control. Yes, my dear.
I don't know this question today, but
Okay.
okay, because Shaw had other things that they are doing apart from their oil blocks.
Yes.
Wouldn't that be a perfect time for them to, I think this goes back to first semester, is it the name that they changed or something, or the objects?
Okay.
Wouldn't that be like a good time for them to rebrand and move forward to doing another thing? Do they have to dissolve?
Good question from an intelligent girl. Shell has subsidiaries. For example, they have All On, they have Easter, they have SNG, Shell, Nigeria Gas, they have Snapco. All these ones that just come are not being affected. So their gas business is still on. Other subsidiaries are on. What they are only selling is their onshore upstream business. So so since the onshore, they are living onshore, they don't want to do anything on Nigerian land. The sabotage, the militancy, the insecurity is just overwhelming. So they just want to operate offshore. I don't know if that answers good. So, forms, please, now we are still continuing. We're looking at the scheme of arrangement. We're looking at the scheme of arrangement that may result, the scheme of arrangement or an arrangement of compromise that may result in the transfer of two companies. Perhaps I should read section 11, section 711, sub 1 for us. Let me just hear. Where under a scheme proposed for a compromise, arrangement or reconstruction between two or more companies. I'll take it again. Where under a scheme proposed for a compromise, arrangement or reconstruction between two or more companies, as is one leg, or the merger of any two or more companies, that is the second leg. The whole of any part of the undertaking of the property of any company concerned in the scheme, in this section referred to as the transferor company, is to be transferred to another company, the transferring company. The court may on application is in summary of any of the companies to be affected, other separate meetings of the companies to be summoned in such manner as it may direct. So what we are having here are basically two scenarios. Number one, we are having a scenario whereby company A and company B, they are not merging. We are not coming together. Instead, company A is saying, oh, you are the one Nigeria Limited, that's your oil block. I want to take it. I want it. In consideration of shares that I will issue to your shareholders. Because I know that oil block is your lifeblood. I want it. So that is the first leg. Are you with me? Are you sure you are with me? Yes. Where under a scheme proposed for a compromise, arrangement or reconstruction between two or more companies, so there could be two or more. And the one happening between Shell now and those companies, actually 4 companies coming together. The whole, everything, the Shell Club in Ukukwe, the Shell IA in the Shell IA premises, assets that the whole or part. Okay, this one is not following, that one is not following. Our investment in LNG, we are sending it back to Snapco, the all parts of the undertaking or property of the company concerned is to be transferred to another company. The 4 companies coming together to take share have now called themselves Renaissance, I think Renaissance Energy or so, Renaissance something. So all the assets, or part of the assets of SPDC, they are moving to Renaissance. Are you with me so far? Yes. The court must first of all be brought into the know. So what will now happen is the procedure. Both companies or any of them will approach the court and say, my Lord, we have reached an arrangement. We have reached a compromise. We have reached a scheme. You have a scheme through which the whole or part of our property undertaking is to move from SPDC to Renaissance. Once you approach the court will now say there should be 2 meetings. 2 separate meetings should be called. I want to hear from the shareholders. Now, it's directors that are approaching me. Directors will always be concerned about profits, job retention. Are you with me? Yes, and most of the time, as people tell them, I hope you are with us. Most of the time, in the course of these discussions, directors can resist any such attempt. And so to ensure that you buy them in, you could enter into several agreements. Because if two companies are going to merge, Company A had 5 directors, Company B has 5 directors. If we merge, we don't want to have 10 directors for God's sake. Is that also? There will definitely be job loss. People will lose their jobs. Ogonda, are you with me? Directors, some people will be retired. Employees will lose their job. Can you have 2 secretaries, 2 legal advisors, everything, 2. Spring Bank merged with one other bank some years ago. I think I printed it out in my book. We talked about it in first semester. After the merger, they said, okay, you were the MD there, you will now be the chairman here. You were the MD. They could not work in peace. A big bank or something like that. So now, because these directors know that they are going to lose their jobs, they may want to enter into some backhand deals. Hefty compensation for loss of office. If not, they will resist any such approach. Are you with me? They will resist it, want to frustrate it, and all that. That is why in first semester, when we look at directors, okay, I didn't teach you with directors, but if you had looked at my book on directors, there are certain transactions a director cannot enter into without the approval of the members. One of them is compensation for loss of office. So if you are going to compensate directors for loss of office, the members must know and approve, particularly if that loss of office is arising as a result of a merger. Okay, but so what will happen now? The directors have approached the court and said, my Lord, we have reached an agreement, we want to now merge. What will the court do? The court will order that separate meetings should be what? Held. Okay, so we have ABC. We have ABC Limited, and then we have ABC Limited plus XYZ. I've decided to come together. We have not come to merger. Let's leave the merger first. ABC is transferring its assets. Let's say an oil block. If it's a shipping company, let's say it has a ship. Are you with me? Yes, so let's leave oil block for some time. Let's say it has a ship that is now moving. And this ship is virtually all that this company has, the lifeblood. Not that it has several, it has just one. The ship is moving to this company, and they have now entered into series of negotiations, and they have agreed shareholders here will become shareholders here, or shareholders here will become creditors here, or shareholders here will hold policies in this company, or whatever form of compensation that they have approved. You approach the court will now say, call for 2 meetings. Because I want to hear directly from the shareholders, and to be sure that they support this scheme overwhelmingly. Are you with me so far? And so when the court calls for this meeting, they will now call the meeting, and in that meeting, subsection 2, please. Please, I'm coming back to the merger. In that meeting, if majority representing at least 3/4 in value of the shares of members being present, voting either in person or by proxy at each of the separate meetings, agree to the scheme, an application will be made to the court to sanction the scheme. So there are 2 applications. First application is a formal notification. My Lord, this is our agreement. We want you to give us the permission to hold the meeting. Then the court will say, hold the meeting. You will now hold this meeting. After the meeting, you go back to the court. My Lord, 3/4 approved here, 3/4 approved here. That means we have overwhelming support, and the court will sanction the scheme. I put a stamp of approval. Are you with me so far? After that, we'll begin to continue to discuss. Sometimes it will take time. For example, the SPDC is being so, but it is believed that the process can continue for the next 24 months. A lot of negotiations. Shell staff who have been pension, share pension. So I know somebody, a relative of mine, has been a share pensioner since 1993. Who is going to pay him now? Is it a Renaissance Assembly? A lot of things, a lot of negotiations. What about outstanding liabilities? There's this new company, I call it Renaissance Assembly because that was the former church. Renaissance Energy or whatever. Check it for me and give example. That company, is it Renaissance Assembly or Renaissance Energy? The company acquiring share quickly and get back to me. Okay, can we continue, please? Good. So that is the first. Just use your phone and check for me. So that is the first one. The first instance, what is passing is an undertaking. Two companies. The second instance is a merger. ABC plus X, Y, Z. This one does not necessarily have to entail a merger. These two companies may not merge into one. Instead, what is happening is that the assets of this company are moving to this one. This one can decide to continue into other businesses. Are you with me? But substantial undertaking has moved from here to here. Go to the court. You know why? Because the property of the company, you know it doesn't belong to the shareholders. You know now. Yes, the company does not hold its assets on trust for its shareholders. The company is not an agent for any of the shareholders. The company holds its assets by itself. It trades for itself. And so if assets, remember again we talk about the capital maintenance rule. You remember? The assets once vested in the company must only be used for the pursuance of its objects, and on no basis whatsoever can those assets be used to be given back to the shareholders. Did I say that? You cannot also use the company's money to support political ventures. Now we are seeing a situation where the laptop of the company is being moved to another company. And as a result of that, Mr. Konyefa, that's your name, sir. Mr. Konyefa is a creditor of this company. He brings an action against the company and hoping to get his assets. That asset no day again. It has moved to that other company. That would be very, very wrong. That is why the court must give an approval. And before giving the approval, the court must be sure that certain things have been done. Otherwise, you cannot transfer a company's capital, property, or undertaking to another company. That's what we are saying. Mr. Felicity, I hope it's not too abstract. It's abstract. Go back and listen to the video. Listen and pray, listen and pray, listen and pray. Light. Can we continue, my friends? Good people. It's a good lecturer. Okay, so in either way, remember again, in the first instance, there's no merger necessarily. In the second instance, the two companies are merging. In either way, the court will now give this approval and then call for this meeting and let us see if you can get 3/4 in value of the share of members. So here we're not looking at numbers, we're not looking at majority of persons, we are looking at majority of investments. So, and the interesting thing is that if I'm a shareholder in this company and I'm a shareholder in this company, I can vote in both meetings. You know now. Deborah, you know. I'm a shareholder in ABC Limited. I have 80% of the shares. That's why I said if the dominant majority approve, there's not much you can do. So, and what usually happens in practice, like what that case I just gave you for Oando and all that, the company that is buying out the shareholders is already a dominant shareholder in the Oando itself. You cannot object except you can say it's oppression. And so if the shareholder attends this meeting, he sanctions the scheme. He attends this meeting, he sanctions the scheme. They go back to the court. When they go back to the court, they tell the court, my Lord, sanction, please. And then the judge must sanction. Are you with me so far? Good. The judge has to sanction because they have approved. So let me just again read something I have here. Okay, I'll come back to it.
This way.
Again, just to draw your attention to the fact that when we are looking at section 711, arrangements of compromise between two or more companies, we are not bringing in creditors here. Creditors are not involved. The people that are approving are shareholders. Shareholders here and shareholders here. It is when we come to compromise with creditors that we are having two separate meetings, one of creditors and one of what? Members, shareholders. So stay with me. Now, when you go back to the court and you notify the judge, how that is recorded?
Yes, I said.
Good. You notify the judge that the meeting has been held. I said the court will sanction the scheme, and the moment that is done, it becomes binding on all the shareholders, whether you attended the meeting or not, whether you agreed or not. Please look at the case of Ojora versus Ajib. It's in my book, but let me post it for you on your platform. I'm sorry, I don't have internet. Later, Ojora versus Ajib. Check it in my book. Check the footnotes. Check the table of cases. Okay, let's move on. Okorote, focus on the master now. After. What else in sanctioning the scheme? Because these are the kind of questions I may ask you. I may ask you in the exam, in sanctioning the scheme of arrangement under section 711, what else may the court do? We need to know section 711 sub 3. I will run through it. It may order the transfer of the undertaking and the property. First, move the ship, move the oil block from ABC to XYZ. 2, transfer of the liabilities of the company. All the people that ABC is owing, it is now XYZ that is owing the money. I don't know if you understand. The next thing the judge will do, transfer liabilities. Oga Koyefa, you dey flow now?
Yes, sir.
Yes. You are acquiring my assets. This asset is my lifeblood. I'm sending it to you. And we're asking the judge to approve. I told you that the moment that asset is gone, what you have in this company is a shell, a skeleton. And so if I was already indebted to this my daughter, Dara, but I said, Dara, sorry, we don't have anything again. No. Why don't you have anything? You used to have a mighty ship. Sorry, we have transferred it to that company. And by virtue of a separate personality rule and limited liability, you can't sue them. That would be nonsensical and unreasonable. So, in acquiring the asset, you also acquire the what? Liabilities. That is the same thing when people get married. You know, I like to use every opportunity because I also believe in you people. Most of you now will get married soon in Jesus' name. When you get married, it is for better for. It's for better for what? Worse. It's asset and liability. You can marry a wife and God forbid she didn't have a child for 10 years. You stay with her. You can marry a husband and he has low sperm count. You must look for solutions and trust God. You can marry a husband, the minute you marry him, he loses his job. I have a friend, and you know, we don't always believe for better for what, always believe for better, and we all hope for better. But the truth is that life happens. There are challenges in life. You just pray that the one that will come against us will be able to overcome. It's for better, for worse. It's asset and liability. You marry a husband, all his family members have become your family members. They're your family members now. You have to relate with them. You must look for a way to work it out. Your husband's father is now your father. I was counseling somebody yesterday. You can't be rude to your wife's father. You can't. And say you want to marry the daughter and be happy. I'm joking. You can't be rude to your wife's mother. I want to have a happy marriage. Now you born the people. You give a person train. You can't be rude to your husband's mother and think your husband will be happy with you. You are joking. One day his eye will open. When his eye will be clear, you know you did what you will do. All your sins will know. I'm telling you from experiences, life experiences. I hope you are hearing what I'm saying. Yes. Not that you're married, and you are now divorced. Particularly those of you who are studying law. You are not divorced. I know my rights. Keep out your rights outside when you enter the home and walk in law. God will do it for you in Jesus' name. Amen. I have married my wife for 15 years. No problem. My wife's father is my father. I can enter his house, enter any room, cause problem there. If I'm the first son of that man, because I honor him. I'm the first. And in fact, my voice is stronger than the voice of his own sons in that marriage. Because I honor him. Okay, let's come back. You've done something, have you not? Yes. Okay, back to what may the courts do? These are the kind of questions I will ask you. Yes, my daughter, quickly.
So you see that sometimes the business that they've sold there,
yes,
etc., can still be going on. The
yes,
creditors now that they don't have that much money to pay.
Yes.
How do they know which one is moving with that asset and which one is staying?
Good question from an intelligent guy. So those are some of the things that they have to negotiate and discuss before the judge will approve and sanction the scheme. Are you with me? Just so let's just flow first. Number one, before approving the scheme, section 711 sub 3, the courts, or in approving the scheme, the court will order the transfer of the undertaking and property. It will order the transfer of liabilities of the transferor company. Are you with me?
Yes, sir.
It will also order for the allotment or appropriation by the transferring company of shares, debentures, policies, or other interests in that company. Perhaps let's read it directly. Section 711(3). Somebody should read for me while I draw some breaths. Start from A. Quickly.
Okay, section 711, subsection 3. When the scheme is sanctioned by the court, it becomes binding on the companies, and the court may, by the order sanctioning the scheme or by any subsequent order, make provision for A, the transfer to the transferring company of the whole or any part of the undertaking and of the property or liabilities of any transferor company.
2.
The allotting or appropriation by the transferring company of shares, debentures, policies, or other like interests in that company, which under the compromise or arrangement are to be allotted or appropriated by that company, to or for any person. C. The continuation by or against the transferring company of legal proceedings pending by or against any transferor company.
Yes.
D. The dissolution without winding up of any transferor company.
Yes.
E. The provision to be made for any persons who, in such manner as the court may direct, dissent from the compromise or arrangement. And
Yes.
F. Such incidental, consequential, and supplemental matters as are necessary to secure that the reconstruction or measure shall be fully and effectively carried out.
Good. So, any points I tell you, I may ask you in exam, please, somebody should write it down. Send me. I don't want the failure rate to be this high. Some of you are already going to stay back because you failed international law, you failed company law. So we don't want that. So be serious. So all those points I'm asking you, I may ask you in the exam. That is what I will ask. So if I'm going to set a question for this topic, and I may ask you, that is what I will ask. So write it down. Do a sample. After send it to me, please, personally. I may ask you in the exam, in approving the scheme, what may the judge do in sanctioning the scheme? And so the judge could say, transfer assets and allot shares to all the shareholders. Allot shares. So XYZ, please look up. XYZ will take the shares of shareholders here, appropriating, and then allot them shares in XYZ. Are you with me? Yes. Your share here is worth 1 naira, but by the time we are taking the allotting you share here, we may allot you share that is worth 80 kobo. That is, if this company was doing badly and we are paying it. If this company was doing very well and we are acquiring it, then it will be higher. Is that so? Good. So that is what should a lot or appropriate. And then legal actions. Legal actions have already been on against SPDC. Now you are not suing SPDC again. It's now Renaissance. My daughter, is it Renaissance Energy? Renaissance what? Rare Holding. No? How do you spell it?
After the Renaissance, then capital R attached to Renaissance.
Okay. Okay, so let's just say Renaissance Holdings. Is that okay? Renaissance Holdings. So you are no longer suing SPDC again. You are now suing Renaissance. That's just an example. You know. Then, if, please look up. If the essential assets of ABC are moving to XYZ, then you've got to say there's no need for ABC to exist. Dissolve it. But in this case, you're not winding it down. You know why? Do you know why you're not winding it? That you're not liquidating it. Because you're not reducing asset to cash. The asset, which is this laptop, liquidation is simply reducing asset to cash. You are not reducing assets to cash. Instead, you are moving the asset from A to B. And so the judge could now say, dissolve the company without what? Winding it up. So ABC will cease to exist. But if ABC had other substantial assets and it wishes to continue its business, then we will still have XYZ and ABC. So what is ABC doing now? They have other things they are doing. Either way, it will happen like that. The next one is the provision can be made for such persons for dissenters, basically. So the judge must also be sure, or the judge will order all those shareholders that do not agree, don't buy their shares. Because like I told you, there could be allotment and appropriation of shares. Please look up. We have 10 shareholders here. Look up and focus. We have 10 shareholders here. And 75% of them agreed. 25% say we don't like this company, they are doing bad things. Their reputation is too bad, we don't agree. The judge, in approving the scheme, would not say, okay, buy them out. These 75% that agreed, give them shares, they are now your shareholders. These other ones that don't want anything to do with you, buy them out. That's what we're trying to say. So please, I know why I'm using all these examples. It's not as though you don't know, but I want to break it down. Okay. Thank you, Lord. Yes. Just a second. Then lastly, the judge will give such incidental, consequential, and supplemental orders necessary to secure the reconstruction, that the reconstruction of measure can be fully and effectively carried out. Yes, my dear. You want to say something?
Yes, sir.
Yes, please. Very good question from an intelligent man. So dissolution is the final death. Winding up is a process. So if this is a company that has these assets, 1, 2, and then 3, winding up is a process whereby we have to now appoint somebody called a liquidator. That person will now auction these 3 assets, reduce the money, and now begin to pay people. Dissolution. So that is winding up and liquidation are the same thing. And when he's through with the payment, that means he's done with winding up. He will now go to the court and say, my Lord, I am done. No, the judge will now give an order, dissolve. After liquidation or winding up is over, the company is dissolved. In this case, we are dissolving without winding up. So we are not appointing any liquidator. Nobody is liquidating the company. They are simply moving its core assets to that other company. And then it ceases to exist. Business continues. So essentially, the business is still a going concern. I just have 5 minutes more. I want to finish this. Section 711. I thought I would round up everything, but it's okay. What else may the court do? Okay, so please note that. But again, before making the order for the dissolve, so I said the court would order that the company should be dissolved without being wound up. But before doing that, it must be convinced that the whole of the undertaking and the property and the assets of the company are being transferred. And that makes sense. If XYZ is going to have, if XYZ has 4 assets, so a ship, a bus, an oil block, a hotel, and only the hotel is moving to, APC, sorry, and only the hotel is moving to XYZ under a scheme of arrangements. This company can still continue with these 3 businesses. Is that not so? You can't order that it should be dissolved because of just this. It doesn't make sense. It is when 1, 2, 3, 4 are going that the court will now order. So before ordering that the company should be dissolved, in approving the scheme, the judge must be sure all of the assets have moved. Secondly, the judge must be sure that you have made adequate provision for employees. Very important. Very important. We're having a problem now. Ajip has acquired Owando. But the concern is the employees. You have been working for Italians, Europeans. These are people that operate with a higher standard, particularly in treating human beings. These are people that if their dog dies, they will cry they will go into depression. They value human being. Now you are working for a black man who does not value human life. What is it? So anytime any black man is working for a white man, he's happy. Because the white man values even his dog and his cat. The moment you move to say you are now working for a black man, you will have trepidation. And rightly so. But once he takes over the company, he goes through the books. How much were they paying them before? 2 million? What are they doing with 2 million? Reduce it to 150,000. They will not work, let them go. Anybody away from union, you are breaking it. Brutal things begin to happen. And so the staff of Ajip were so concerned. According to what I heard, the day they were going, they held the aeroplane. They are not going anywhere. Should it be like that? Should it be like that? No. When the Americans were leaving Afghanistan, people come to the plane because they knew the Taliban was coming. You have not been reading now. They read this paper, they read law. All the phone you carry is TikTok. Snap picture. When the Americans were leaving Afghanistan, people clung to the plane. The plane was flying, they said no, some of them fell down and died. Because the people coming to take over are evil. All the advancements they made, Taliban has rolled it back. Women don't go to school again. Cover your face. All the oppression has returned. So, everywhere you go, treat people well. Treat people well. So, adequate provision by way of compensation must have been made for the employees. That's what I'm meant to say. Please see section 745. In this respect, provision must also be made for employees or former employees. I'm not talking about pension. Or the company subsidiary in connection with mergers and transfers of undertaking. Even where this is not in the best interest of the company. I think I will stop here. Thank you, Lord.
Thank you, Jesus.
Okay. Let me just say something on these 2 slides. So I know I'm done on this one. So I said there will be transfer of property and there will be transfer of liabilities. Spurgeon, are you with me? Transfer of property and transfer of what? Liability. What is liability? In this case, the definition for liability is broadened by the statutes to also encompass, please look up, to also encompass technical skill. You guys are doing labor law. You know that ordinarily under labor law you cannot transfer a person's service. You know that? Have you been taught that? Why is that so? Under labor law, you cannot transfer a person's service ordinarily. Because it's not something you can assign. It's something of a personal nature. It's a contract of a personal nature. Contracts of personal nature are non-assignable without the consent of the person. If I employ Deborah to work for me, it is believed that in working for me, she has considered my person. I cannot wake up and say, you are no longer working for me, and you signed a contract with me to work for me for 10 years, and you have transferred your service to that man. You must go and work for him for 10 years. No, you can't do that. Because it's the service of a personal what? Nature. And so the law factoring that provides here that liabilities includes rights, powers, and duties of every description, notwithstanding that such rights, powers, or duties are of a personal character, which could not generally be assigned or performed vicariously. What it means now is that if Shell, SPDC, is selling its onshore oil blocks to Renaissance Holdings, and the agreement says that Renaissance Holdings will automatically acquire all SPDC's employees, Renaissance cannot say to those employees, "I'm not like on her face." Because a contract of service is a contract of a personal nature. So I will not acquire you. They can't say that. Renaissance cannot say that. Renaissance must absorb the employees of Shell. And that is what they are still negotiating. Ma? If the employees don't want it, it's a different matter. As an employee, because the constitution is generally against what we call servitude, slavery. So if as an employee now, you don't want, no problem. But if at the time when SPDC was employing you, there was such a clause that at some point we may transfer your service, then you have to accept. If you don't accept, you will breach your contract. They cannot compel you, but you pay damages. We'll punish you small. Are you with me so far?
Yes, sir.
Okay, last slide. And as I'm leaving here, I run at the wrong. Publicity and notice. Publicity and notice. See section 7:11 sub 6 to ensure that adequate publicity and regulatory notification is given to the scheme. CAMA imposes additional obligations on the companies involved. It requires them to file a court order with CAC while ensuring that a notice to that end is published in the Federal Gazette in at least one national newspaper. Are you with me so far? Furthermore, the court may also order that any property, this one is misplaced. This one should have been among what the court will order. So basically, when we meet next week, we will start from dissenting shareholders, the rule of dissenting shareholders. Then we will now talk about arrangements for sale and compromise with creditors. Thank you. I love you all.